So without further ado, we'll launch into our session for today. As I mentioned, this is a part of our online learning series on humanitarian law and policy, and the title for today's session is Legal Foundations for Humanitarian Access in Situations of Armed Conflict. Now I'll go through the learning objectives for today's session before introducing our expert for the day. So first of all, we're going to be really focusing on enhancing familiarity with the relevant IHL, that's International Humanitarian Law, principles and rules regulating humanitarian access. Also be working on improving understanding of the main legal questions for a humanitarian practitioner to consider when assessing issues in their work related to access. Also, looking at the knowledge of the different stakeholders involved in humanitarian access situations and trying to build a greater familiarity with the different rights and obligations of these different actors under IHL. And finally, aiming to build awareness of the key debates and challenges found within the legal framework of access, including the issue of state consent, which of course is oft discussed issue among humanitarian actors, but also other actors involved in these situations. I would like to mention actually that many of you did submit already questions before today's event, and they were excellent questions. We've actually incorporated a number of them already into the presentation today. We have a lot of material to cover in the presentation, and your questions were very helpful in assisting us to shape the presentation to really address your concerns. So thank you very much to those of you who submitted questions in advance. And again, we will have time at the end for additional live Q&A. I'll also mention that for those of you who are PHAP members and are participating in the Continuous Learning Credits program of the association, please do listen for the 4-digit assessment code that our presenter will read out at the end of the presentation. You'll need that code to access the assessment at the end. And then a final note before I introduce Beth. Today we really are focusing on the foundations of humanitarian access in situations of armed conflict, the legal foundations, but we are going to be offering an additional session in the coming month or two that will focus more on current legal and policy debates and challenges. So do look for that coming up in the calendar, and we'll send around an announcement about it as well. It's such a big topic that we couldn't address it all in just one session. So today we'll be focusing on the foundations, and then we'll take up some additional issues in the next month or two. So now it's my great pleasure to welcome and introduce Elizabeth Holland, who is with PHAP currently as a consulting expert on international humanitarian law, and I think many of you know her as the usual host for these online learning series events on humanitarian law and policy. Today, as Elizabeth will be giving the presentation, I'm helping out as host and particularly to facilitate the Q&A. So now I'll pass the floor over to you, Elizabeth, and we'll take it away.
Great. Thank you very much, Ann-Herod, and hello to everyone. It's wonderful to see some familiar names out there, and welcome to those who are joining us for the first time. I hope we see you back again soon. So it's a pleasure to be here to discuss this topic, and it's very nice to be on the other side of the mic, so to speak. So as Ann-Herod mentioned, today we'll be discussing the legal foundations for humanitarian access in situations of armed conflict. And as Ann-Herod also flagged for you, this is just but one component of an incredibly large topic, and that is that of accessing the affected populations during armed conflict. And so it's a topic that implicates both legal, policy, ethical, operational, a variety of different questions. And so a very good place to begin the conversation is the legal framework. And so that's what we will do today. So I will begin by providing you an outline of today's event, And I'd like to echo Anhered's invitation to submit questions to the right, but also please do share your experiences in the panel to the left. And there'll be a few points at which I will invite people to add. I'll enumerate lists and I'll invite you to add your own additions. So today we'll talk about humanitarian access. And as I noted, it's a multifaceted issue, and it is perhaps one of the issues within IHL that has the greatest consequence for the civilian population. So it's an incredibly important topic, and we will be focusing here exclusively on the legal framework. And this was an intentional ordering by PHAP because the utility of a discussion about the legalities allows us to have a shared reference point, common vocabulary, and a grounding on which to build argumentation and negotiation, etc. So that's why we are beginning with the legal framework. Once we talk about sort of the scope, we'll then talk about the challenges. And I appreciate that this might be a slightly non-traditional ordering, but I'd like to just introduce the challenges up front because then this will allow us to keep those in the forefront of our minds as we're walking through the legal rules and the terminology, etc. And hopefully it will help spur a better understanding for us as to how we might approach some of the challenges. Next, we'll look at some of the basic rules. Now, this will not be simply a cataloging of the relevant treaty and customary rules. I'll provide that at the end on a slide, in fact. But rather, what we'll talk about here is more of a normative discussion, a descriptive analysis of the rules. We'll also then look at some of the key elements, rules, and terminology. And in conclusion, we'll look at perhaps sort of two elements. One is what human rights law has to say about humanitarian access, and also we'll look briefly at cross-border operations, which is a topic that has certainly induced a great deal of conversation and debate. So without any further ado, let's jump right in. And here we'll talk about the landscape. Now I'll begin with a reminder that we're talking here about simply situations of armed conflict. And so we're talking here about international armed conflict. That's a situation where you have a state against a state or multiple states against one or more states. So in terms of, if you'd like to think about a lawyer v, if you will, meaning party 1 versus v, party 2, if you have a state on both sides of the v, you have an international armed conflict. We're also going to be talking about non-international armed conflicts. Those are situations wherein you may have a non-state armed group involved. And so in any context, or almost any context, in which you have an armed group on one or both sides of the V, then you're talking about non-international armed conflict. And we'll also reference briefly situations of occupation. And that's where a territory of one state has fallen under the effective control of the armed forces of another. So we'll talk about the treaty and the customary rules relevant to each. And here it's because the wording it differs amongst the different contexts. So it helps to know the differences, but also because it allows us to still nonetheless pull from rules across the board, because these rules may well represent the spirit of IHL and sort of what IHL intends to do. So we do not want to take an overly stringent approach at what rules apply to which scenario. We'll also here be focusing, of course, on the legal framework of humanitarian law, but many of the questions that will be raised have implications for public international law, international human rights law, international criminal law, and domestic law. And as a reminder, we'll be looking here when we're speaking about the law, we'll be looking at both treaties, and in particular, of course, we'll be talking about the 4 Geneva Conventions and additional protocols 1 and 2, And we'll also be talking about customary international law. And here I'll make good note of the customary international law study published by the ICRC, because there not only are there rules relevant to access and assistance more generally, but there's also a cataloging of the relevant state practice. So for those of you looking beyond treaty to custom, the ICRC study provides a very helpful free online tool. And I suspect that my colleagues in Geneva will have the link up very shortly before I go to even to the next slide. Next, we also have the role of the law. And here, I'd like to be clear that this is not sort of the end of the discussion, but rather it's the foundation and the beginning of the discussion. So here we want to talk about the utility of the law and not a legal analysis as an end in and of itself. The law can, of course, inform negotiations. It can provide a background to what is, in essence, almost always a political process. And it also bears remembering that simply because something may be considered lawful or legal, that does certainly not mean that it is safe and or feasible under the circumstances at the time. So one need not want to rely too heavily on a legal analysis or the outcome of a legal analysis, but rather one does want to appreciate the value of it and the utility of it in ensuring that there's a common reference point, a shared understanding of vocabulary, and that, of course, the activities proposed are in accordance with the relevant legal frameworks. And here I include IHL and public international law. And we'd also like to note, of course, that particularly in the context of humanitarian assistance, precedent is very important. Perception of the parties to the conflict and other stakeholders is very important. And so what one decides to do, whether as a matter of law, ethics, policy, or operational considerations, will almost surely carry a precedent not only for that situation and that actor, but also for those across the humanitarian enterprise and those actors within the enterprise. So not just the one actor who makes the decision, but many of those other actors who may be seen to be cooperating with that actor, or who may be simply be painted with the same humanitarian brush. So a word of caution to those who are in the position to make decisions related to access and assistance, to think thoughtfully and strategically about the precedent decisions may set. And so here, as I'm going through the challenges to access, I would certainly invite those of you who are familiar and who deal with this on a regular basis to share your own lists of challenges. And so here, I think at the top of many lists would be, of course, the politicization of assistance. And that is the treatment of access and assistance as a political tool, as a bargaining chip, as something to be leveraged. And that just simply runs counter or contrary to how it's conceptualized and dealt with in IHL. Impartiality is fundamental and critical to access and assistance. And so access and assistance should never be politicized. But of course, I think many of you can give numerous examples in context in which it has been. Now, for those on the ground, there can, of course, be burdensome administrative measures imposed by both the state and a non-state actor. There may be security risks that are faced by the staff, by, of course, the populations that the staff is trying to reach. There's logistical hurdles that must be overcome. And there is the legal challenges, and that's the challenge related to interpretation, to application and enforcement of the law. And one might see this, of course, when you have legal debates, a number of which we will identify and raise today. And those can be sort of as significant as fundamental theoretical debates, or sort of dealing more with the minutia of what a specific term, how that term may be defined. But I think at its core, many of these challenges will manifest the attempt to balance state sovereignty on the one hand and the humanitarian imperative on the other. Now, for those of you who work often with IHL, you know that there is a constant balancing that goes on. And we often say it's between military necessity and humanitarian considerations. In this specific context of access, we'll be talking a bit more about the balancing between state sovereignty and the humanitarian imperative, and this is found quite present in the wording in the additional protocols 1 and 2, which we will flag. I'd like to also share with you what I thought was an interesting quote to remember, particularly when one is faced with legal challenges related to interpretation or application. This is found in the commentary to Article 10 of the Fourth Geneva Convention. Now, this is called sometimes Common Article 910 because it is an article found in all 4 Geneva Conventions. It's Article 9 in the first 3, Article 10 in the 4th. Now, the commentary to this states that no one can foresee what a future war may be like or under what conditions it may be waged. Therefore, it is proper to leave open the door for any initiative or activity, and this is humanitarian in nature, that may be unforeseeable at the time that the protocols were drafted, but which may in the future be of real assistance in protecting civilians. And I think this is a very helpful reminder that IHL is not a static framework, that it should be considered to be dynamic and adaptable. And it's something to keep in mind when the debate arises, as it usually and cyclically does, questioning the sufficiency or the adequacy of IHL to address contemporary conditions. Now, I will leave that debate to another time, but I think this particular concept or thoughtful approach is worth remembering. So now we'll move on to the basic rules. And the first that I will introduce to you is that of the primary responsibility for the well-being of the population. And that rule states that the primary responsibility for the population is held by, and typically it's held by the state. Now, in IHL, which IHL is rather unique within the broader sphere of public international law, as addressing both states and non-state armed groups. And so here, many will say that the primary responsibility for the well-being of the civilian population lies with that party who exerts authority over the civilian population. So traditionally, that was always conceived of as the state, and that was sort of a natural corollary to sovereignty. That if a state, of course, has sovereignty, then the state, in turn, has responsibility for the well-being of the population. There's been a development in this concept, and so it is generally accepted now that an armed group who exercises authority and has the capacity to do so is therefore also obligated or is responsible for the well-being of the civilian population. Now, if a humanitarian organization comes in to, let's say, address needs that the state or the armed group is unwilling or unable to meet, this is considered to be complementary to that. In other words, the humanitarian organization is coming in on top of the state or the armed group. So by coming in, the organization in no way alleviates the responsibility of the state or armed group. So that primary responsibility remains. Next, humanitarian and impartial organizations have what we refer to as the right of initiative. This is the right to offer their services to a party to the conflict. Now, this includes the right to offer their services to the state as well as a non-state armed group. Offers can be made if there is demonstrable need on the part of the civilian population, but they may also be made preemptively or preventatively. In other words, so long as an organization is humanitarian and impartial, they are privileged, in essence, to make an offer of services to a state or an armed group. Now, This right of initiative does not translate into what is often described as an unfettered or an absolute right of access. Rather, consent is required in order for access to be obtained. The corollary to this, meaning the fact that consent is required, reflects the concerns of states to protect their state sovereignty. The flip side, or the balancing here, is that consent may not be arbitrarily withheld. So if there is demonstrable need, and that need is unmet, whether or not the authority is unwilling or unable, and a humanitarian and impartial organization makes an offer of services, a state or non-group may not arbitrarily withhold their consent. And shortly we'll talk about what arbitrary may look like. Furthermore, once the relief actions are agreed to, the parties to the conflict are under an obligation to allow and facilitate rapid and unimpeded passage of the consignments, the equipment necessary to deliver, and the personnel. Now here we're focusing, of course, on, let's say, the territorial state. But as you will see, there are also obligations on the part of third states, and we will identify those shortly. Flowing from this general obligation is the obligation to ensure freedom of movement of authorized humanitarian personnel. And also the fact, or the corollary, is that humanitarian personnel and objects must be respected and protected under all circumstances. Now, it bears noting here that the freedom of movement that the parties are obligated to facilitate is subject to restrictions in the case of imperative military necessity. Now, that is very restricted both temporally and geographically. So it may not be used as an excuse, let's say, to suspend long-term humanitarian operations. But military necessity may serve as a basis to temporarily suspend operations should the circumstances so demand. Now that we've covered in brief the rules, I'd like to turn quickly to terminology. And here we'll talk first about humanitarian access. I think, as Julia Andrews says in The Sound of Music, let's start at the very beginning. It's a very good place to start. We will begin by looking at access itself. And rather unhelpfully, it is not defined in IHL. So we look elsewhere, and we look to the spirit of IHL, and we look to other rules of IHL. So when we're talking about access, we're talking about both short and long-term access. And we're able to speak about it with reference to IHL with some degree of detail because it is a precondition to effective assistance. So when there are articles under IHL that reference assistance, because access is a sine qua non, it's a precondition, well, we can then read into what IHL may say about access. So we can also look here at about what does assistance mean under IHL. And generally one may say the humanitarian assistance aims to ensure that the civilian population and those hors de combat may survive and live in dignity. Now that seems very straightforward and a statement with which one can find no fault. Now, however, as is often the case in IHL, one might say the devil is in the details. There is, on the one hand, an approach to humanitarian assistance that defines it very restrictively as life-saving and life-sustaining materials. And the basis for this is there are a number of articles found in the conventions and the protocols that reference lists. And they say relief consignments such as clothing, bedding, medicine, food, etc. These are all consignments or relief consignments that one would say would be urgently needed under certain conditions. On the other hand, there's language to be found in IHL that talks about protection and relief. So for instance, Common Article 99910, which is such a mouthful, Common Article 99910 references relief operations undertaken for the protection of civilians and for their relief. So this provides grounds to suggest that humanitarian assistance may be conceived of more broadly, that it may be conceived of as all those activities seeking to preserve life, security, dignity, both mental and physical well-being of civilians and those hors de combat. So this would enlarge what assistance might be conceived of as entailing. And of course, the reference to protection brings in the various definitions of protection that have been adopted by, for instance, various UN agencies, funds, programs, the ICRC, etc. So without getting too much into the debate about the parameters of assistance, suffice to say, at the very basic, at the most basic level, assistance is that which is necessary for individuals to survive and live in dignity. It is also in reference to all those affected. So very often we say the civilian population for shorthand, but it bears remembering that under certain conditions, there are a number of rules that also apply to those hors de combat. So that also includes fighters who are out of combat, who are sick, who are wounded, who have been detained, etc. So strictly speaking, humanitarian assistance in its broadest sense applies to all those affected by the conflict who are hors de combat and not just civilians. It includes both material, services, activities, and the actions of delivery. And it should also be considered to include the practicalities of delivering assistance. So that's things like undertaking a needs assessment, having the relevant or the necessary administrative processes in place, the transportation necessary to actually operationalize assistance, distribution mechanisms and facilities, etc. So moving on from humanitarian access, we'll talk next about the concept of the responsibility of parties to the conflict. And here, again, we'll reiterate the notion that each party to the armed conflict bears primary responsibility for the population under control. This responsibility is not diminished by the presence of organizations. And here I provide for you just a few references in the law so that you can see sort of the basis for this notion as it's found in IHL. But suffice to say, it's a necessary corollary to sovereignty. And because we don't talk about sovereignty and armed groups in the same breath, it's really for the purposes of armed groups, for the application of this concept to armed groups. It's a corollary to the authority that an armed group may exert. So if you have an armed group exerting authority over a civilian population, a corollary to this is that they therefore have responsibility for the population. So here you have sort of the legal basis for the concept of the primary responsibility. And then here you have an eloquent articulation of this, which is found in GA Res 46182, which is quoted very often when discussing humanitarian assistance. And this was the Res from 1991 on strengthening the coordination of humanitarian emergency assistance. So if we can set sort of that aside, we have the responsibility of the party concept. Now we will move to the concept of right of initiative. Now this is an important concept. It's enshrined in Common Article 3. You see reference to Common Article 3 and right of initiative very frequently. And this is in essence means that if there is an organization which is humanitarian and impartial in nature, That organization has a privileged position, if you will, under IHL. And that is that that organization may offer its services to a party to the conflict. Now here, sort of legal nuance and technicality is quite important. Common Article 3, which is Article 3 to all 4 of the Geneva Conventions, applies to non-international armed conflict. And one should note that the use of the term party here means state and armed groups. And how do we know that? We know that because in contradistinction, meaning in most other articles, when referencing states, the term high contracting party is used. So when you see parties and not high contracting parties, one knows that the article is addressing both states and armed groups. Now, here it bears just a bit of reminding what the principle of impartiality and humanity means. I don't want to delve too deeply into this. This was covered in previous sessions here and will no doubt be covered in later sessions. But as a reminder, humanity it encompasses humanitarian objectives, and that is essentially the survival, the well-being, and the dignity of all those affected by armed conflict. And impartiality means that an organization operates in accordance with the notions of non-discrimination and proportionality, meaning no adverse distinction is included in their operations based on such elements as race, color, or religion. And very closely related to this is the idea that assistance is provided on the basis of need alone. So in other words, there's almost a triaging in effect. So impartiality means there's no discrimination adopted by the organization, and that the assistance is provided based on need alone. Now, neutrality and independence, of course, are very important as well, but it bears noting that these are not found in IHL. They're not referenced in IHL. Humanity and impartiality, or humanitarian impartiality, are referenced expressly in IHL. Neutrality and independence are found, for instance, in the guiding principles of the Red Cross, Red Crescent, and have certainly developed in practice as 2 of the 4 fundamental principles. But insofar as the legal framework is concerned, humanitarian and impartial are what is referenced in IHL. Now, just heading back here, if you will, we also have the notion that offering services, if you're humanitarian and impartial, and therefore you have a privileged position under IHL, your offer of services cannot be conceived of as unlawful intervention in the sovereign affairs of the state. Now, this traces or triggers public international law concerns. So it should come as no surprise that when negotiating additional protocols 1 and 2, states were concerned about protecting their sovereignty. So in fact, there are cases in which, for instance, for one of the draft articles for the protocols, there was no reference to state consent. Rather, the wording was, if the civilian population is inadequately supplied, for instance with foodstuffs, clothing, etc., the parties to the conflict shall agree to and facilitate those relief actions which are exclusively humanitarian and impartial in character and conducted without any adverse distinction. That was the draft language. So note there that there's no reference to consent. However, in the interests of coming to mutual agreement, the notion of consent was introduced in the relevant articles in both Additional Protocol 1 and Additional Protocol 2. So you can see the concern of state sovereignty was sort of informing the development and the negotiating of these rules. So when you talk about sort of unlawful intervention, violations of territorial integrity or independence, this is getting into the realm of public international law, but there are considerations that are present in IHL. So moving on, and if you'll excuse me, we'll skip through that. We'll now move to consent. Consent is one of the most critical elements of the access regime, if you will. It is subject to some debate under certain conditions, and here I'm referencing in particular cross-border operations, and we'll get to that very, very briefly. Now, we're referencing here again that balancing between state sovereignty and the humanitarian imperative, and what I'll provide for you here is treaty language that provide examples of the references to consent. So you'll see here that it's present. The requirement of state consent is present in both IAC and NIAC treaty rules. In occupation is where the language is sort of the most stringent, and it doesn't in fact mention consent. Instead, it says the occupying power shall agree to relief schemes. Now, there are some conditionalities there where the occupying power is able to, you know, affirm to itself that it's not concerned that, for instance, any of the consignments may be diverted inappropriately. You know, they may prescribe the technical arrangements, curfew schedules, etc. But under occupation, the occupying power must agree to relief schemes under the conditions stated. In IAC and NIAC, you have the requirement of state consent. Now, as a practical matter, one would also say that consent by an armed group, if one is going to operate on the territory controlled by the armed group, is absolutely necessary. But here it is helpful to differentiate between technical, strict legal requirement for state consent and the more practical, operational, and of course safety-oriented question of, do we have the consent of all the necessary concerned parties? And at the end of the day, it may well be, is the consent that is operationally necessary, has that been obtained? That is of the utmost importance. Now, the flip side of consent being required is that a decision to grant that consent is not discretionary. In other words, a state may not arbitrarily or capriciously, that's the language often seen, a state may not arbitrarily or capriciously decline or withhold its consent. Now here I've provided you some references to occupation, Article 23 of the 4th Geneva Convention, etc., where these are specialized cases regarding consent, and in the Q&A we'll take up a few of these. Now, as again is often the case, one is introduced to terms which seem quite clear in their meaning, arbitrary, for instance, but when one looks to IHL for the definition, it is absent. So arbitrarily or capriciously is not defined in IHL, but what there are some examples of what may, under certain conditions, be defined as arbitrary bases for refusal. And then here are some examples of bases that may be valid cases of refusal. Now, what I will note here is that there is an interesting debate about imperative military necessity. Now, some say imperative military necessity may serve as a valid ground to withhold consent, while others say it is only a valid ground to temporarily and geographically restrict operations once consent has been granted. So there are two interpretations of whether or not military necessity may serve as a basis for, on the one hand, refusing consent, or on the other, having consent granted, but then restricting it under certain circumstances. So we can pick that up again in the Q&A, but that's something important to flag for you as one of the sort of the present debates. So in addition to consent, the requirement of consent, and the flip side of that, which is the obligation to provide consent if there are needs on the part of the civilian population or those otherwise entitled to assistance, and those needs are not being met whether the authority is unable or unwilling, and there's an organization that's humanitarian and impartial in nature who's offered its services, then consent cannot be withheld arbitrarily. Now, moving on, presuming consent has been issued, and I will just take one step back here and note that there's no technical instruction in IHL as to what consent might look like. So it could be implicit, tacit, inferred. It could be explicit. It could be so much as a matter of a general practice in which a state is aware of a humanitarian organization operating and has just simply not objected. So there are a variety of manifestations, if you will, of consent. Now, facilitation. Generally speaking, once an authority, state or armed group has provided consent, then they must allow and facilitate the rapid and unimpeded passage. So now that you have this obligation on the one hand to facilitate rapid and unimpeded passage, and here I will provide some examples for you as to what that may look like in terms of facilitation in practice. I will also note that you have the role of third states. So you have the primary authority who's provided consent and is now obligated to facilitate that. And you have third parties. And you have third parties who also are under the express obligation in IAC, and let me give you the relevant language. They are under the express obligation in IAC to allow and facilitate. And under NIAC, though there isn't sort of the concomitant obligation, one can presume or argue that it exists. One, because of simply the spirit and nature of IHL, but also because there's just simply an expectation that a third state would do so just to carry out their general obligations under IHL in good faith, but also because if they were to interfere inappropriately or unnecessarily, then that would, in essence, render any consent void. So you have this obligation present in IAC and NIAC and also in occupation. Now, there also is the corollary to this obligation to facilitate the right of control. And that, for instance, is that the authority in question can verify that the relief in question is humanitarian. They can prescribe certain technical arrangements. And on the flip side, the authority cannot interfere with the principled approach of the organization and cannot divert any of the consignments, and they, of course, cannot force the organization to distribute in a way desired by the authority that would violate the principled approach. Related to this is the obligation to ensure the freedom of movement of authorized personnel. And again, there may be temporary restrictions on the basis of imperative military necessity, and there's the obligation to protect relief consignments. And here I will provide for you two helpful rules that stem from the International Committee of the Red Cross Customary International Law Study. And we will also then very briefly, because I have an eye on the time, will introduce to you the notion that human rights law applies, and apologies for that, we'll back up. Human rights law applies as a complementary framework to IHL during armed conflict. Now, we don't want to spend too much time on this, but it bears noting that there are also arguments that may be found in the human rights framework that can buttress or supplement those under IHL. And indeed, in some cases, there may be stronger arguments to be found when addressing states under human rights framework. Now, this is something that will be addressed in later sessions within sort of the larger online learning series. And now I will discuss briefly cross-border operations because we got a number of questions on this, and it will be my suspicion that this is something we can take up in the Q&A as a sort of something that many people will be asking about. Now, cross-border operations, it's important to note that this is not a legal term, cross-border operations, but rather it's more of a technical descriptive term. It implicates both questions of IHL and public international law. And at its heart, where there is a debate, the debate is in the context, and this is a subset of what a whole variety of cross-border operations can look like. So the debate really lies with just a subset of these types of operations. And those are the delivery of humanitarian assistance across national borders to a territory that's under the authority of an armed group, where the territorial state has arbitrarily withheld or denied consent. So that's the case, that's the context in which there is a debate. And the debate there is whether or not state consent is required. Now, many will say, and the majority opinion will say, that state consent is categorically, unequivocally required. There are some creative arguments that are being advanced that suggest that based on the language of Article 18 AP2, as well as sort of the theoretical underpinnings and the language of Common Article 3, that under certain circumstances, primarily where an armed group controls territory and access to that territory may cross a border, but it does not go over territory controlled by that state. Therefore, the state is not concerned, so to say, that under those limited conditions, state consent may not be necessary. So that's the brief synopsis of what is a rather creative argument being advanced. But the majority opinion to date is that state consent is required. And so I think with that, I will beg your forgiveness for running over time, but I hope I've taken some of the time usually allocated to live Q&A to address the huge number of questions we received in advance that we were able to tailor this session for. So what I will note for you is that for the recording, you will have this list of IHL references that may be helpful for those of you working on this on a daily basis. I will also do my part by sharing with you the assessment code, which is 6790, for those of you interested in taking the assessment afterwards. Here I have my moderator hat on. And now I will hand over the moderator hat to Untitled for the Q&A.
Okay, great. Thanks so much, Elizabeth, and thanks for the presentation. Really rich, and I think I'm sure was a great resource for those of us here today, but will also be a great resource for everyone to be able to access as the recording afterwards. So thanks so much for all your work in putting that together. We have received a lot of great questions here. We have 10 minutes, so we'll see how many we can get to. I'll start with a question from Richard in Nigeria. Richard is asking, are there laws that inhibit humanitarian access negotiation that have extraterritorial jurisdiction? And I think he may be asking about inhibiting humanitarian access negotiation with certain parties to conflicts. And Richard asks, what are their implications for such laws for humanitarian work? I know this is a big question, but I'll give you a crack at it. Over to you.
Sure, thank you. It's a very interesting question, and it's one with implications beyond just IHL, of course. So when one is considering the variety of potential legal sources that would implicate legal liability for an actor, one needs to consider IHL, public international law, human rights, criminal law, but particularly, and for NGOs, this is of sort of very important consequence, it's domestic law. Really, it's domestic law. IHL doesn't address NGOs in terms of, legal liability. So one would want to look at domestic law. And here we would note, and this will be the subject of a later online learning series on sort of counterterrorism regulations. But if I understand your question correctly, this may be a matter of the proliferation of counterterrorism regulations, both at the regional and at the domestic level. Now, many of these regulations do have extraterritorial effect, and these are in essence domestic law that carry criminal and/or civil penalty for those who transgress them. As a general rule, simple negotiation, that is just engagement on its face, is not prohibited. And here I'm using as a reference point the counterterrorism regulations of the United States government, because these have been used as a framework or an example for others, and they are widely considered to be the most stringent in their scope and effect. So simple engagement or negotiation is generally not prohibited, but it is the operationalization of this relationship that may be prohibited, strictly speaking, by these regulations, and that is, let's say, the provision of any type of material to anyone who is listed as a terrorist or a terrorist organization. So these counterterrorism regulations can be difficult or challenging, not only from a criminal and civil liability perspective, but also because the language is found increasingly in donor contracts and grants. And so this speaks also to just simple contract liability and relationship and the security of your relationship with a donor or a grantor. So these also these types of regulations are also a very significant challenge and in certain cases an infringement on humanitarian assistance more generally.
Okay, great, thank you. We have a question now coming from Sane, who writes, thank you for a solid overview. Is there a little more to say about, quote, burdensome administrative procedures? In an extreme case, could burdensome customs regulations, for example, constitute an illegitimate barrier to humanitarian access under IHL?
Excellent question, and I think the short answer is yes. One never wants to give categorical answers in legal terms to hypothetical questions, but I think under the circumstances you describe, yes. Essentially setting up a bureaucratic or an administrative framework that is so burdensome, so exacting, that its practical effect is to preclude the ability of the humanitarian and impartial organization to undertake its operations, then yes, that would in practice amount to an arbitrary refusal or let's say suspension. You know, here one could quibble over the verbiage, but it would be an arbitrary refusal or suspension of consent, yes.
Okay, great, thanks. And now we've got another question from Prerna. She's asking about a crisis context such as Yemen, where political pressure is used by certain states to block humanitarian aid and restrict it only to civilian populations, justified on the grounds of denying assistance to insurgents. What legal arguments could be made to allow aid into the country against politically imposed blockades?
Sure. Well, here there's no rule that sort of is specifically addresses that context, but one needs to take a step back and remember that international humanitarian law as a framework was addressed or was developed to address that very scenario, that there would be armed conflict situations in which fighters or members of the armed forces are in the same general territory as the civilian population. So the idea that one could cordon off an entire area simply because of the presence of fighters, that is prohibited under IHL. In other words, the presence of fighters, for instance, can't be used as sort of to make the whole of a group sort of a military target. That's, for instance, a rule of conduct of hostilities. So there are a variety of ways in which IHL makes clear that the presence of fighters is not legitimate grounds for preventing humanitarian access. And that's exactly why all of these safeguards are found in IHL. That's why organizations that are humanitarian and impartial, meaning they will not be providing assistance to fighters, that's why they have the privileged position. That's why, for instance, there are articles like Articles 17 and 23 of the Fourth Geneva Convention that address the cases of siege and blockade, and they require that certain affected populations or certain particularly vulnerable groups, they must be addressed. Their needs must be accounted for. So IHL does presume that there may be cases in which, of course, there'll be fighters and the civilian population intermingling, but there are a number of safeguards present in IHL that are sufficient to ensure that the relief does not inappropriately is not inappropriately diverted to fighters or belligerents per se.
That's great. Thank you, Elizabeth. We have time, I think, for one more question. We had a good question coming from Jamal, who asks, what mechanisms are available to ensure that those blocking the humanitarian access, whether they're state or non-state actors, are dealt with in accordance with IHL? I know this is a concern to many in the group today.
Of course, and properly so. And if I could do what is called a punt, I'd like to invite people to join us for future sessions, including one upcoming on ICL and humanitarian actors. But the short answer is one can look to a number of different frameworks, and ICL is one of them. So IHL and ICL. So I will point here in appreciation of our limited time, to starvation. So one way is that there's the prohibition of starvation. This is found in IHL, in both IAC and NIAC, and it's also included in the Rome Statute as a war crime in IAC. So if the denial of access would amount, in other words, to starvation as a method of warfare, then there would be international criminal liability as a war crime. There have also been interesting creative arguments put forth that under certain conditions, the denial of access or assistance could amount to crimes against humanity, which is, a widespread or systematic attack directed against a civilian population, which could include extermination. And extermination has been defined as the deprivation of food and medicine, for instance, calculated to bring about the destruction of a group. So there are some components of ICL that could be helpful in terms of criminal responsibility, but then there's also just simply accountability sort of under public international law, responsibility of a state for an internationally wrongful act. And that wrongful act would be sort of withholding of consent arbitrarily, unlawfully under IHL. So there's draft articles, for instance, on state responsibility that address and acknowledge state accountability in the context of wrongful acts committed by that state. So there are violations per se of IHL, public international law, and ICL that one could look to.
That's excellent. Thanks so much, Elizabeth. And I know that there is a lot more to say on that specific question, but also, of course, on the whole topic of humanitarian access in situations of armed conflict. So thankfully, we will have another opportunity coming up within the next weeks where we'll have, as Elizabeth mentioned, an additional session on access, looking at some of these particularly thorny challenges, which are both legal and political, as we all know. So wrapping things up then, I'll just go through a few closing points here. First of all, the recording of today's session, as well as a set of related resources and the link to the assessment questions is available at the link that you see on your screen there, or I should say will be available very shortly, because it does take an hour or two to process the recording, and you will all, as participants, receive an email with that link as well. I'll also highlight a few upcoming events. So first, in our series on humanitarian law and policy, this online learning series, our next upcoming event on the 17th of November is entitled Strike at Kunduz, an IHL analysis. And we mentioned this as well in the chat following Kathleen's comment. That should be a very interesting discussion for this very current and concerning case. I hope that many of you will be able to join us then on the 17th of November. In the same series, we have coming up on the 2nd of December a session on the International Criminal Court and humanitarian actors, I think also very much related to several of the issues that came up today. So please do try to join us for that as well. And then we're introducing a new series, and I would like to highlight this, and particularly for those of you in the virtual room today who are really working with IHL on a regular basis, our legal advisors, our IHL experts in various organizations. But for anyone as well who is really interested in a deep dive on some related issues, we're launching a new series entitled PHAP Expert IHL Briefings. And our first in this series will be building on a research report coming out of Harvard Law School entitled Medical Care in Armed Conflict, IHL and State Responses to Terrorism. And we will have as our guest experts Naz Modirzadeh and Dustin Lewis of the program on International Law and Armed Conflict at Harvard University. That will be on the 3rd of November. And then a second event in this same expert IHL briefing series will be entitled Suppressing Foreign Terrorist Fighters and Supporting Principled Humanitarian Action. That will be also in cooperation with our colleagues at PLAC, Naz Modirzadeh and Dustin Lewis, and will take place on the 17th of December. One more event for which we don't have a slide, but I'd like to give a quick shout out here, not a PHAP event, but an event of one of our partner organizations, the STITE, which is the Senior Transformative Agenda Implementation Team, will organize on the 17th of November their own online event on humanitarian access, which will be a complementary discussion to the one we've had here today with some legal components, but also some of the policy challenges. So we'd very much encourage all of you who are interested in the subject of access to participate with them on the 17th of November. As soon as we have all of the details from the STITE team, we will circulate those as well on the PHAP website. But please do make a note, the 17th of November for the STITE event on access. So then, apologies for going a bit over time, a very rich discussion today in which we covered a lot of ground. I'd like to give a big thank you to Elizabeth Holland, PHAP's consulting expert on international humanitarian law and our presenter today, also typical host of the online learning series on humanitarian law and policy. Thanks so much, Elizabeth. I'd also like to thank Marcus Forsberg for all of his work in managing this series and putting everything together behind the scenes, as well as our assistant Suranjana Das and current intern Prerna Baghi. Big thank you to the entire PHAP team for their efforts, and wishing all of you participants a wonderful morning, afternoon, or evening, depending on from where in the world you're logging in, and very much looking forward to seeing you again online in the near future. This is Anne Lang signing off from PHAP in Geneva.